At 7:10, on a Monday morning, a soil rig was boring into my West Hay meadow, while 6 strangers studied a glossy plan of the houses they intended to build there. The orange stakes marked 12 rectangles across a hay meadow my family had worked for 74 years. A white utility pickup sat in the ruts. Beside it, Evelyn Shaw held a leather folio as if she were conducting an ordinary site inspection. I parked at the stone wall and did not drive into the crowd. I photographed the rig, the truck, every stake, and the 2 test pits already open in the field. Then I asked the operator who had authorized entry. He pointed to Evelyn. She said, the Stonebridge Ridge Board had released the land as new home sites, that 12 purchase and sale agreements were already signed and supposedly binding, and that the first buyer had been promised a closing 12 days after the final plat was recorded. This is Mercer Farm, I said. Show me the instrument that conveyed it. Evelyn did not raise her voice. She opened the folio and handed me a reduced survey sheet. The title block described a Stonebridge expansion revision 6. Her signature appeared below a line, identifying her as authorized land representative. Behind her, a woman with a navy folder looked from Evelyn to me and quietly asked whether I was the farmer. I was. I also knew that a revision number is not decoration. For 31 years I had administered contracts for an agricultural cooperative. When a supplier changed a specification, the revision, authorization, and delivery date had to agree. This sheet carried a survey company mark I recognized from an old farm file, but the layout was not the plan my father had shown me. I did not touch the rig or pull a stake. I gave the operator a written notice that ownership was disputed, asked him to preserve his work order, and called the county sheriff, only to keep the peace. Then, I watched Evelyn tell the buyers that I was delaying a project already approved. I wrote down her exact words. The buyers had signed contracts for land. I had not yet learned what conditions those contracts contained, or why revision 6 would matter more than my deed. My name is Daniel Mercer. I was 62 that autumn, and Mercer Farm was the one address that had followed me through every part of my life. The farmhouse was modest. The barn leaned a little east. The apple rows produced less each year. None of that made the place disposable. My grandfather bought the first 40 acres after returning from war. My father added the meadow in 2 purchases and laid the low stone wall by hand. When his knees began to fail, I came home on weekends to cut hay and repair fence. After my wife died, those weekends became longer. When my father died, the farm passed to me under a recorded deed with a surveyed legal description and no mortgage. The West Meadow mattered because it was the working center of the farm. Hay from those 24 acres carried our small cattle herd through winter. My father had refused several development offers, not because he disliked houses, but because cutting the meadow into lots would leave the remaining farm unable to support itself. During his last spring, I promised him I would keep that ground in production, as long as I could still climb onto a tractor. Stonebridge Ridge sat beyond our northern apple rows in Bellwether County, North Carolina, along the western edge of the state. It was a private subdivision of 84 homes, governed by a homeowners association, a member-run corporation that enforced recorded rules inside its own boundaries. The entrance had stone columns, clipped shrubs, and a private wastewater pump station, hidden behind cedar fencing. Our farm used a septic system and shared none of their private infrastructure. Evelyn had been board president for 7 years. She did not behave like a theatrical bully. Her letters were carefully spaced. Her meetings began on time. She used phrases such as community continuity, planned growth, and fiduciary responsibility. People listened because she sounded prepared, and because most volunteer boards are grateful when one person agrees to master the paperwork. By noon that Monday, the sheriff's deputy had recorded the names of everyone present. We explained that he could prevent a confrontation, but he could not decide title in a field. The drilling operator suspended work after seeing my deed and Evelyn's plan. That was his business decision, not a legal ruling. He capped the open holes with temporary covers and left his stakes in place. I spent the afternoon establishing a baseline. I walked the meadow in parallel lines, photographed every rut, measured each test pit, and marked the stake coordinates on a farm map. I saved the original images to 2 drives and sent copies to Aaron Bell, a land use attorney who had helped our cooperative with warehouse leases. I did not ask Aaron to threaten anyone. I asked him to tell me what I did not yet know. The next morning, I visited the Bellwether County Register of Deeds. That office maintains recorded property instruments. It files them, but does not decide contested ownership. The parcel index still listed all 86 acres under my name. There was no deed from a Mercer to Stonebridge Ridge, no recorded option against the farm, and no subdivision plat covering my meadow. That should have been comforting. It was not enough. Evelyn's survey sheet referred to a declaration recorded when Stonebridge was first planned. The old developer had drawn a dotted future expansion area across part of our farm in 1988. My father had kept a copy because the developer once asked to buy the meadow. A concept on paper was not a transfer, but the declaration also reserved certain annexation rights. I needed to know whether those rights had ever reached the HOA. The strangers in the meadow were not investors in a faceless scheme. They were ordinary buyers. One of them, Lydia Chen, called me that evening after finding my number through the farm website. She had recently retired from hospital administration and wanted a single-story home near her sister. Evelyn had shown her lot 7 beside the apple rows. Lydia spoke slowly, embarrassed by a situation she had not created. She had signed a purchase and sale agreement and paid $7,500 in earnest money to an independent escrow account named in the contract. Closing was conditioned on title clearance, county subdivision approval, final plat recordation, and delivery of a deed. The agreement identified the seller as Stonebridge Ridge Homeowners Association, acting through Evelyn Shaw, president. "Did anyone show you a deed?" I asked. "They showed us the expansion map," she said. "We were told the land had been committed years ago." I asked her to keep every email and not send me confidential material. Her own attorney advised her to withhold. I did not tell her she had been foolish. A polished map, a board president, a community clubhouse, and an escrow instruction can look like a complete transaction. Her question was the same as mine. What had Evelyn used to convince people she could sell? Aaron met me at the farm the following day. He wore work shoes instead of courtroom shoes and spent an hour walking the proposed lots. He examined the temporary covers over the test pits, then stood where the marketing board faced the Stonebridge entrance. "Ownership and development authority are separate questions," he said. "Your deed is strong evidence of ownership. Their declaration may still create an argument about annexation. We find the chain before we announce the conclusion." That was the kind of advice I trusted. We sent a preservation letter to the HOA, its management company, and the survey contractor. It requested the authority for entry, the board resolution, every purchase agreement, and all versions of the expansion plan. It also demanded that no further work occur while title and access remained disputed. Evelyn replied the same afternoon. Her response did not include a deed, it said. Stonebridge had succeeded to the original developer's rights, that the farm had long been designated for planned residential use, and that interference could expose me to claims from 12 families. She called the soil testing a permitted due diligence activity. I printed the message, noted its receipt time, and filed it. The phrase 12 families mattered. Only 6 buyers had been at the meadow. Evelyn had signed purchase agreements covering every proposed lot, or she wanted me to believe she had. Aaron contacted county planning, the department that reviews subdivision layouts, roads, wastewater capacity, and building applications. The planning director would not decide ownership either. He could, however, verify whether an owner authorization accompanied the pending concept application. It had not. The application named the HOA as applicant and attached Evelyn's certification that she controlled the land. The county placed the application on administrative hold. No permits would issue until the applicant supplied acceptable owner authorization or a court order that stopped new physical work. But it did not rescind the purchase agreements. It did not remove the stakes, release the earnest money, or answer the old declaration. Evelyn described the hold to residents as a routine technical delay caused by my refusal to cooperate. 3 evenings later, the HOA held a special meeting in its clubhouse. I was not a member, but Aaron asked permission for us to attend because my property was the only agenda item. Evelyn agreed, provided that we spoke for 5 minutes and did not disrupt board business. The room held nearly 60 residents and 4 buyers. A projection screen showed the meadow divided into 12 pale green lots. Evelyn explained that expansion would preserve Stonebridge's financial stability and protect existing owners from an extraordinary assessment. Her tone remained controlled. She never said my family had signed a deed. She said the land had been committed to the Stonebridge plan. When my turn came, I put 1 page on the table. The current county parcel index, I said. I had found no recorded conveyance, annexation, or owner authorization. I asked the board to suspend marketing, cancel every purchase agreement, and release the earnest money until a title company could confirm its authority. Evelyn turned to the secretary. The secretary read a resolution adopted at the board's April 23 meeting. It authorized Evelyn to investigate expansion feasibility, retain consultants, and negotiate non-binding reservations, subject to title review. It did not authorize entry onto my land. It did not authorize her to certify that the HOA controlled the property. It did not authorize purchase agreements she could represent as binding or a sale. I watched two directors look down at their copies. They had voted for a study and non-binding reservations. Evelyn had converted that limited authority into signed purchase agreements she called binding. Still, the closing conditions gave her more room than I wanted. She could argue that no deed was due unless title cleared and the final plat was recorded. Evelyn closed the discussion by saying the board would let council resolve the technical record. Then she addressed the residents rather than me. This project is how we protect 84 households from a major infrastructure burden, she said. One adjoining owner should not be able to erase decades of planning. There was no shouting that made the pressure more effective. I left through a row of people who had just been told that my meadow stood between them and a large bill. A small reversal had stopped the drill. The larger claim had become a community cause. Over the next week, Aaron and I separated three things. Evelyn kept blending together a future development sketch, a special declarant right to add property, and ownership of the property itself. The 1988 sketch showed what the original developer hoped to build. The declaration described land that might later be added to Stonebridge. Neither document conveyed my father's meadow. The original expansion period had once been scheduled to end in 2009, but a recorded 2006 amendment extended it through the end of 2011. The amendment added a disputed savings clause. If the developer acquired title, obtained and timely exercised a binding option, or secured written owner consent before that deadline, the supplemental declaration and final plat could be completed afterward. That clause kept the old plan from collapsing on dates alone. In 2010, before the extended deadline, the developer recorded an instrument conveying Stonebridge's common areas and expressly assigning all special declarant rights and rights under written land agreements to the HOA. Both sides executed it. North Carolina requires a transfer of special declarant rights to appear in a recorded instrument, so Aaron did not dismiss it. The instrument did not transfer my acreage, he said, but if a valid 2008 land agreement and a timely exercise existed, a judge would have to read the amendment, the assignment, and those documents together. We hired a licensed surveyor to locate the recorded boundary, not to decide title. He found the line where my father always said it was, north of the stone wall and outside every recorded Stonebridge plat. The temporary lot stakes were far inside my farm. The survey gave us reliable ground positions and damage measurements. It did not erase the declaration's disputed language. I returned to the old concept plan. In the lower right corner, 6 revision rows had been added over time. The copy from my father's cabinet ended at revision 2. Evelyn's sheet showed revision 6 and 12 lots arranged around a short cul-de-sac. I noted the survey firm's name and sent a preservation request, but I did not yet know when the later version had been created or for whom. Meanwhile, the conflict moved from paper back into the field. 2 buyers drove through the open farm gate on a Saturday to view their proposed lots. They said Evelyn had told them the planning hold did not affect private inspections. They were courteous and left when I asked, but their tires flattened a strip of standing hay. I installed a plain chain at the gravel lane with a private property notice. I also created a sign-in point for invited farm visitors. Evelyn photographed the chain from the public shoulder and sent residents a message saying I had blocked access to the future Stonebridge extension. She did not mention that Stonebridge never possessed access across the farm. The following morning, I found 3 survey stakes pulled and placed beside the chain. That could have been a buyer, a contractor, or a curious resident. I did not accuse Evelyn without evidence. I photographed the change and placed the stakes in labeled evidence sleeves. The missing markers complicated our damage survey, but their movement proved nothing about who had moved them. The farm's operating lender noticed the county planning hold through a routine review of my seasonal credit line. The bank did not cancel anything, but it asked whether a title dispute was developing. I supplied the deed, survey, and Aaron's letter. The credit officer said the line would remain available unless a recorded claim or lawsuit affected the parcel. That warning changed the cost of waiting. I used the credit line each winter for seed, fuel, veterinary work, and equipment repairs before hay revenue arrived. Evelyn did not need to win the farm to hurt it. while she only needed to create enough uncertainty that ordinary institutions became cautious. Aaron sent a formal demand. It offered the HOA 10 business days to withdraw the planning application, terminate the purchase agreements, identify the escrow holder, and fund restoration of the meadow. In exchange, we would refrain from seeking immediate court relief while the records were corrected. It was not a settlement of title. It was a controlled way to stop additional loss. Evelyn's response came through Association Counsel. The letter denied trespass because it said the HOA held successor development rights, and the soil contractor entered under licensed authority. It characterized the contracts as binding but conditional, and the earnest money as refundable if title failed. Then it warned that my chain and notices interfered with contractual expectations created in reliance on the historical expansion plan. I read the letter at the kitchen table. The language was more careful than Evelyn's field statements. It did not say the HOA owned the meadow. It said the HOA possessed rights that could allow the meadow to be added later. That distinction was how they intended to survive the absence of a deed. Lydia called again. Evelyn had invited buyers to a private briefing and assured them the seller's authority would be confirmed before the title contingency deadline. Lydia asked whether I wanted to meet. Aaron suggested a neutral place and told me to discuss facts, not strategy. We sat in a small diner near the county offices. Lydia brought her purchase agreement and a printed email she was free to share. The contract made her earnest money refundable if title clearance or final plat recordation failed. The email was less cautious. Evelyn had written that Stonebridge controlled the expansion parcel and expected only ministerial county approval. I sold my house faster because of this. Lydia said, I can recover the earnest money. I cannot recover 3 months. That was the first moment. I felt anger toward Evelyn, rather than concern about her claim. She was using careful conditions in the contract and unconditional confidence. Everywhere else, I still did not tell Lydia how to proceed. I gave her the contact information for an independent title attorney and asked permission to let Aaron retain a copy of the email. She agreed. 2 days before our demand period expired, an overnight envelope arrived at the farmhouse. Stonebridge Ridge had filed a civil action in North Carolina Superior Court asking for a declaration that the HOA inherited the developer's special declarant rights, held a valid land agreement, and could complete annexation of the West Meadow because the action affected title to real property. Its attorney also filed a separate notice of lis pendens with the Bellwether County Clerk of Superior Court and had it cross-indexed against my parcel. The notice of lis pendens did not transfer ownership or prove Stonebridge's claim. Under North Carolina procedure, it gave constructive notice that pending litigation could affect title. That was enough. The bank froze new draws on my seasonal line while its counsel reviewed the case. The timing left me with seed already ordered and a tractor transmission waiting at the repair shop. Stonebridge also moved for a preliminary injunction under North Carolina Rule 65. It asked the court to prevent me from removing markers, denying scheduled inspections, or changing the meadow while the case proceeded. The filing described my ordinary hay operation as a threat to the proposed development layout. Evelyn had turned my continued use of my land into the conduct the court was being asked to restrain. Aaron called before I finished reading. Do not underestimate it, he said, and do not overreact to it. A filing states one side's allegations, we answer with evidence. I wanted to drive to the clubhouse and put the frozen bank letter on Evelyn's desk. Instead, I made a list seed invoice, repair estimate, cattle feed schedule, expected hay dates. I had spent my career teaching younger contract managers that a real loss must be measured while it occurs. Memory grows cleaner and less accurate with time. For the next 12 days, I paid farm expenses from personal savings and delayed the tractor repair. I photographed the meadow every morning from the same 4 positions. Rain softened the tire ruts and filled one test pit around its cap. I hired no one to fix it because changing the site before the preliminary injunction hearing could support Evelyn's accusation. The restraint was harder than it sounds. My father had taught me never to leave open damage in a working field. Every trip past those orange stakes felt like neglect, yet cutting them out or filling the pits would destroy the baseline and give the HOA a new argument. I left them where they were and recorded why. At night, I organized the litigation file into authority, entry, buyers, damage, and chronology. Aaron handled the law. I handled the sequence. The first marketing email we received in document exchange predated the April 23 board vote. So did the survey contractor's proposal. Evelyn had asked for a 12-lot layout before the board authorized even a feasibility study. That fact was useful, but not decisive. A board president may gather information before a vote. The stronger question was what she had told the contractor and buyers about her authority. We requested work orders, plan versions, escrow communications, and the complete original developer file kept by the association. The HOA resisted several requests as excessive. The court set limited discovery before the preliminary injunction hearing. Each side had to produce documents directly related to annexation authority, site access, and buyer commitments. There would be no instant trial and no dramatic ruling from a roadside conversation. There would be a narrow, noticed hearing built from authenticated records. The motive emerged from the HOA's reserve study. Stonebridge's private pump station needed replacement, and the association faced a projected $480,000 gap. The expansion budget assumed developer contributions from 12 new houses would fill most of it. Evelyn had presented that projection to the board before she commissioned the later survey layout. For the first time, her target made complete sense. She had not chosen my meadow merely because she liked control. It was the only open ground beside the existing sewer line, and 12 homes were the number the engineer believed the pump project could support. If the lots disappeared, so did the financial plan she had promised residents. Understanding the motive did not make the entry lawful. It did make Evelyn more dangerous. Admitting uncertainty now would mean telling 84 households that her solution to their reserve crisis depended on land the HOA might never have possessed. She had every reason to push the old documents as far as they could go. The first production from Stonebridge showed why the case could not be dismissed with one deed. The recorded 2010 instrument did expressly assign special declarant rights under written land agreements. But Mercer Farm was not listed as conveyed property, and no farm agreement was attached. The HOA had a plausible chain for whatever rights the developer actually possessed, but it still had to prove that those rights reached my meadow. The association minutes created a second problem for Evelyn. At the April 23 meeting, one director had asked whether Stonebridge owned the meadow. The minutes recorded council's advice that title and annexation rights required further investigation. The board then approved feasibility work only. Evelyn had signed the buyer emails and the county control certification after receiving that warning. Aaron prepared our opposition around those limits. We would show clean farm title, no recorded supplemental declaration, no authorization for entry, and no board vote empowering Evelyn to sign purchase agreements. The 2010 assignment could transfer existing special declarant rights, but it could not create farm ownership by itself. Stonebridge's insurer appointed separate counsel, and the escrow holder confirmed that no earnest money had been released to the HOA. Lydia's title attorney requested a formal preliminary search. The title company would not insure any conveyance from Stonebridge because the HOA was not the record owner. That did not decide the lawsuit, but it changed the buyer's position. Lydia demanded cancellation and return of her earnest money. 2 other buyers followed. Evelyn responded with a community message saying premature withdrawals could weaken the association's negotiating position. She reminded buyers that alternative lots in the county were scarce. She also told residents that the title company had reviewed only current ownership, not Stonebridge's historical development rights. That was a fair decision stated for an unfair purpose. A special declarant right is not present title. But if the court found that my father had granted an enforceable option and that the developer properly exercised it before the 2011 deadline, the HOA could argue that the recorded 2010 assignment carried that contractual right and that the later plan merely completed it. Our early documents made Evelyn's conduct look reckless. They did not yet close that route. The missing items arrived in Stonebridge's second production. The first was a 1-page document titled Farm Expansion Consent and Limited Option. Dated in 2008, it bore what looked like my father's signature and, in exchange for stated consideration, granted the developer an assignable option through the end of 2011 to add the West Meadow to the declaration. The option required written exercise delivered to the owner before the deadline. Behind it was a second scan titled Notice of Exercise of Farm Expansion Option, dated December 19, 2011. Addressed to my father at the farm. It claimed the developer was exercising the option and would complete the supplemental declaration and final plat under the savings clause. There was no original notice, envelope, mailing receipt, or delivery record in the production. I read it once and felt the room change around me. My father had never mentioned signing such a consent. His decision to preserve the meadow had shaped the last 20 years of our farm. Yet the signature was close enough that I could not dismiss it from memory. Aaron did not ask whether I believed either page. He asked, what could be verified? Was the option recorded? No. Where were the originals? The scans came from the developer file, and Association Counsel said neither original could be located. Who was the notary on the option? A former employee of the development company. Was there an attachment? The option referred to the attached Revision 6 plan, but Stonebridge produced no attachment. The document recited consideration, but the HOA found no canceled check or accounting entry, showing it had been paid. Who sent the exercise notice, and how was it delivered to my father? The production did not say. The two scans created the exact gap Evelyn needed for her counterattack, even though they were unrecorded and did not convey title. An authentic option followed by timely exercise could support contractual rights and an argument that the developer acted before the deadline. Stonebridge amended its preliminary injunction motion and attached both documents. Evelyn's affidavit stated that she found them together during a review of archived developer boxes. The bank extended its freeze. The county kept the planning application on hold, but the lawsuit now carried a document bearing the prior owner's apparent agreement. Aaron warned that a judge might preserve the status quo by restricting both sides until the paper was authenticated. For me, status quo meant a meadow I could not safely repair and credit I could not use. I went to the barn and opened my father's old steel file cabinet. He kept machinery manuals, while seed records, farm maps, and correspondence in labeled hanging folders. I found his copy of the 1988 concept, ending at Revision 2. I found the developer's purchase offers, each marked declined in his handwriting. I did not find the consent or the exercise notice. The absence from his cabinet proved little. My father misplaced receipts in coffee tins and once stored a tractor title inside a veterinary handbook. I refused to build our case on an idealized picture of his filing habits. Instead, I compared the document's components. The signature needed an examiner and original ink to assess properly. The notary needed a journal, if one existed. The access language required legal interpretation. The plan reference was something I understood immediately. Revision 6 had to exist before anyone could attach it. I returned to the survey sheet. Evelyn handed me in the opening field. Its revision block carried several entries, but the reduced copy made the dates difficult to read. Our preservation request had already identified the survey firm. Laren issued a subpoena for its project file rather than calling an employee and inviting an informal recollection. While we waited, Evelyn used both scans at a second special meeting. Lydia invited me as her guest after the board opened part of the session to affected buyers. The plan was displayed beside enlarged images of the consent and exercise notice. Evelyn said the documents confirmed that the Mercer family had approved expansion years earlier, and that the developer had exercised its option on time. She called my objection a later change of heart. I sat at the rear with my hands folded. Responding before authentication would only help her frame the issue as father against son. Lydia raised the important question instead. If this gave you the right to contract for the land, she asked, why was title clearance still a condition in our purchase agreements? Evelyn answered that responsible sellers use standard protections. Lydia asked why the current title company would not insure the sale. Association counsel stepped in and said the dispute required judicial clarification. While several residents began reading the displayed consent more closely, but no crowd turned on Evelyn. The pump station problem remained real, and many wanted the paper to be valid. After the meeting, one director approached Aaron in the parking area. He would not discuss privileged legal advice, but he confirmed a procedural point. The board had never seen either scan before Evelyn found them. They were not the basis for the April 23 vote or the earlier buyer marketing. She had used one theory to begin the project and a different theory to defend it. That inconsistency affected credibility, not authenticity. The hearing was approaching. Stonebridge offered to lift its request concerning hay operations if I allowed limited engineering access and agreed not to challenge the purchase agreements publicly. I declined. A temporary compromise that treated disputed access as legitimate would become another fact Evelyn could call reliance. The survey firm produced its file 5 days later. Revision 6 had been created on May 14, 2013, 5 years after the date on the farm expansion consent. The firm had prepared it for the original developer during a brief attempt to revive the subdivision after the housing market recovered. Its invoice described converting the earlier concept into a 12-lot preliminary layout. I did not celebrate. A revision date on a plan could be a clerical convention, and Stonebridge would say the consent referred to a plan later updated under the same project. We needed the actual connection, not an attractive inference. The production contained a transmittal email and a project log. On May 14, 2013, the survey firm's manager sent the first file carrying the Revision 6 designation to two recipients, the developer and Evelyn, who was then chair of Stonebridge's planning committee. The message asked them to review the newly numbered lots and the relocated cul-de-sac. No earlier Revision 6 existed in the firm's system. That changed the meaning of Evelyn's opening survey sheet. She had received the first revision 5 years after my father supposedly signed a consent expressly referring to it. More importantly, she had personal notice of when that revision was created. The discrepancy did not depend on my memory of my father's signature. Aaron requested the native electronic files of both scans from the HOA. Stonebridge had only copies saved during Evelyn's archive review. Their metadata showed scan dates, not when either document had been created. The former developer employee who notarized the option had retired out of state and no longer had a journal from that period. No employee with personal knowledge could identify the exercise notice, its preparation, or its delivery. Those limits meant we could not claim who created either page or when. We did not need to overclaim. Our immediate issue was whether the scans reliably proved an option and a timely exercise strong enough for preliminary relief. A page dated in 2008 could not have attached a specifically named plan first created in 2013, and a notice dated before the deadline was not proof that the notice had been delivered as the option required. Stonebridge's counsel attacked both points before the hearing. He argued that Revision 6 might refer to a private development sequence independent of the survey firm's formal revision table. He also argued that my father could have consented to expansion generally, with the later plan substituted as an updated attachment, and that a properly addressed notice found in the developer's file supported an inference of ordinary mailing. Aaron expected both arguments. The survey firm's custodian agreed to authenticate its ordinary business records, the job log, invoice, original file history, and transmittal email. Lydia's title attorney agreed to explain only the title company's decision, not ownership itself. Our noticed papers opposed Stonebridge's motion and included a cross motion for a preliminary injunction barring further entry and marketing. Aaron also arranged the security North Carolina Rule 65 required if our motion was granted. Evelyn made one final move. The evening before the hearing, Stonebridge filed declarations from 4 buyers saying they had spent money in reliance on their signed purchase agreements. Lydia refused to sign. The other buyers described design fees, moving plans, and lost opportunities. Their harm was genuine, even if the HOA had caused it. For a few hours, that was the hardest part of the case. A judge could see 12 households facing an infrastructure bill, buyers caught in uncertainty, and one farmer with record title. Evelyn wanted the dispute to look like a choice between my attachment to open land and everyone else's practical needs. Our evidence had to return the responsibility to the person who claimed authority before she verified it. The preliminary injunction hearing began on October 9 in a North Carolina civil courtroom with oak paneling and tall windows. It was not a trial on every claim. The judge had to decide what restrictions, if any, were justified while the case continued. Stonebridge asked for survey access and protection of its alleged expansion rights. We asked to keep the HOA off the farm and prevent its motion from paralyzing ordinary operations. Evelyn testified first. She described the reserve crisis, the historical plan, and her belief that the HOA succeeded to the developer's special declarant rights, and that the developer had exercised the option on time. She said she understood the purchase agreements to be binding but conditional. When asked why she certified control of the land to the county, she said control included the right to pursue annexation. Her counsel introduced the farm expansion consent and the alleged 2011 exercise notice. Aaron objected to treating either scan as conclusive without a sufficient foundation. The option lacked its complete plan attachment and a witness with personal knowledge of execution. The notice lacked proof of delivery or a witness who sent it. The judge admitted both scans for the limited hearing, but made clear that admission did not establish their truth. On cross-examination, Aaron did not accuse Evelyn of forgery. He walked through decisions. She agreed that the board authorized feasibility on April 23. She agreed that marketing had started earlier. She agreed that counsel had advised further title investigation. She agreed. She had signed the county certification and told buyers Stonebridge controlled the expansion parcel. Then Aaron asked when she first saw Revision 6. Evelyn said she could not remember. He showed her the 2013 transmittal email. She acknowledged her address and did not dispute receiving it. Her counsel objected that a later revision could implement an earlier consent. The judge allowed the question, but reserved the legal conclusion. The survey firm's records custodian explained how revision numbers were assigned. Revision 6 was not a generic project label. It was the sixth log change to that drawing. Created May 14, 2013. The original electronic history, invoice, and delivery record all agreed. The custodian had no record of any plan carrying that designation in 2008. Stonebridge's counsel pressed him. Could another office have used the same words earlier? Possibly. Could the developer have called something Revision 6 privately? We could not know. Had the witness watched my father sign anything? No, the cross-examination preserved a theoretical escape, but it also clarified how much speculation the HOA needed. Aaron placed the consent and survey email side by side. The consent did not merely approve future development. It referred to the attached Revision 6 plan. Stonebridge had produced no earlier attachment, no cover letter, no log entry, and no witness who had seen the page in 2008. Evelyn had received the documented Revision 6 in 2013, then later found a consent dated 5 years earlier, using the same designation. He then turned to the exercise notice. The missing original was only one gap. Stonebridge also had no envelope, certified mail receipt, outgoing mail entry, or witness who sent it. The page said the option was exercised, but nothing showed delivery before the deadline. Lydia's title attorney took the stand, briefly. She did not tell the judge who owned the land. She explained that the title company found no recorded interest, allowing Stonebridge to convey a home site, and would not insure a deed from the HOA. A conditional purchase agreement could be canceled, and the earnest money returned if its conditions failed, she said. But the contract did not create title in the seller. Evelyn's counsel returned to buyer reliance. 4 families had changed plans because of the project. The association had spent money on surveys. Residents faced the pump station gap. We argued that barring access would preserve my position while destroying theirs. The judge asked one question. What verified interest did Stonebridge possess when those commitments were made? The counsel pointed to successor rights, the preliminary plan, the option, and the alleged exercise notice. The judge noted that successor rights remained disputed. A plan was not a conveyance, and the 2 scans required much more proof. The ruling was measured. Stonebridge's preliminary injunction motion was denied. Instead, the court entered a preliminary injunction barring the HOA and its agents from entering the farm, marketing specific home sites, or representing that it controlled Mercer Farm while the title case proceeded. I could resume normal agricultural work, fill the test pits, and remove temporary markers after preserving them. The notice of lis pendens remained because the underlying action was still pending, but the court ordered an expedited title schedule. It was not total victory. The bank wanted the notice of lis pendens canceled, not merely a preliminary order protecting the meadow. The buyers still needed their earnest money released. The field still carried damage. Yet on the courthouse steps, Lydia received an email from the escrow holder, confirming that her cancellation request would be processed. The practical balance had changed. Over the next 6 weeks, Stonebridge's position narrowed. Its insurer reviewed the entry, purchase agreements, and board authorization records. 2 directors called a properly noticed meeting and obtained an independent opinion. The association withdrew its claim that it could sell or enter the meadow, while preserving only its request for interpretation of the 2006 amendment, the 2010 assignment, and the alleged option and exercise notice. After discovery closed, Aaron moved for summary judgment on the title claims. The judge did not decide whether my father's signature looked genuine or choose which witness to believe. Stonebridge had to produce admissible evidence for each essential link in its claim. It could not lay a sufficient foundation for the option. The missing original was not decisive by itself, but the absent attachment, the contradictory 2013 business records, the lack of a knowledgeable witness, and the absence of any reliable history predating the scan raised a genuine question about authenticity. The document recited consideration, but Stonebridge found no canceled check or accounting entry showing payment. Aaron did not claim that omission alone defeated the option, only that it left another material link unverified. The alleged exercise notice, failed independently. Stonebridge had no envelope, mailing receipt, delivery log, or witness with personal knowledge that notice reached my father before the deadline. Because the option required delivered written exercise, a date printed on a scan was not enough. Stonebridge could not produce admissible evidence of an authenticated agreement or a timely exercise of the alleged option. With no deed or supplemental declaration adding Mercer Farm, no triable title issue remained. The court entered a final order declaring that the HOA held no title, option, right of entry, or power to convey homesites on Mercer Farm. After Stonebridge dismissed the remaining claim, the judge ordered the Bellwether County Clerk of Superior Court to cancel the notice of Liz Pendens in the record of Liz Pendens. The bank restored my seasonal credit after its counsel verified the cancellation. Every buyer's earnest money was returned from escrow. Stonebridge's insurer and the association settled my restoration and legal fee claims with a $38,400 payment, and I released the individual residents who had relied on Evelyn's statements. Lydia recovered her money before signing a lease near her sister. Stonebridge's members then followed North Carolina procedure. Instead of improvising authority, the notice for a special meeting identified Evelyn's proposed removal. A quorum attended, and a majority of the owners present and entitled to vote removed her from the executive board. The reconstituted board elected a new president under the bylaws. Evelyn defended her intentions, but the vote ended her authority without spectacle. The new board dealt with the pump station through a lawful reserve plan and phased assessments. It was less appealing than 12 new houses, but it placed the real infrastructure cost before the people who actually owned Stonebridge lots. Evelyn had not invented the need. She had tried to solve it with an asset the association did not control. After the final hay cutting, a contractor removed the marketing board, pulled the remaining stakes, filled the test pits, and graded the tire ruts. Lydia visited before winter, and we walked from the stone wall to the apple rows, where Lot 7 had appeared on her plan. She said. The meadow was as beautiful as Evelyn had promised. I told her beauty was never the problem, authority was. If someone tried to market part of your property as their own, what would you document first? By the following summer, fresh grass covered the repaired ground. The rebuilt tractor pulled the first loaded hay wagon across the west meadow without steering around test pits or sales markers. I stopped beside the barn and watched it move toward the stack yard. My father had never objected to neighbors or new homes. He objected to treating a working farm as vacant space awaiting someone else's plan. The case taught me that a deed is the beginning of protection, not the whole of it. Ownership survives when someone records the intrusion, separates confidence from authority, and waits until every claim must meet its own date, signature, and chain of proof.